If it pleases the court, my name is Laura Riddel and I appear for the defendant, Mr. Marshall Ike. Your Honour, I'll be making two submissions via video link on behalf of my client today. Firstly, that the confession obtained by the arresting officers was in breach of Section 421 of the Police Powers and Responsibilities Act. And secondly, that the questions put to my client during his interview were improper for the purposes of Section 21 of the Queensland Evidence Act. On these grounds, I'll ask that Your Honour exercises his discretion, exclude the evidence from court, and quash the indictment. Beginning with the issue of my client's age. Your Honour, Section 421 of the Police Powers and Responsibilities Act prescribes that if a police officer wants to question a relevant person, and the police officer reasonably suspects that that person is a child, the officer must not question the child unless before questioning starts, the police officer has, if practical, allowed the child to speak to a support person, chosen by the child in circumstances in which the conversation will not be overheard, and that support person remains present while the child is being questioned. On the facts, the arresting officer refers to my client as young fella on a number of occasions. It could be inferred from the officer's evaluation of Mr. Ike's age that he suspected him to be a child when he proceeded to question him about a string of burglaries in the neighbourhood after his arrest. The interview was conducted in the officer's car. They drove around the neighbourhood and pointed to different complainants' homes and asked if he'd broken into them. 84 in total. This was extremely poor conduct on behalf of the police. When it became apparent that they had a minor in their custody, they should have immediately located a parental guardian to have them accompanied to the police station and be present during questioning. It would not have been impractical to do so, and there is no excuse that comes to mind for why the police have deviated from procedure. Further to this, upon reaching the police station, Mr. Ike was introduced to a social worker who was to be his designated support person. Your Honour, whilst police had provided a support person, she was not a person of my client's choosing, as per the legislation instructs, yet another breach of the provision. For these reasons, I submit that any confession derived from this interview was obtained unlawfully. I ask that Your Honour exercises his discretion and excludes the confession from evidence. It is in public interest to protect vulnerable individuals like my client from unfair treatment. Otherwise, to allow the evidence, as per Justice Lyons, could give encouragement to flaunt the law to those officers whose task it is to uphold it. If we are to consider the 5 factors which inform a decision to exercise the public policy discretion, there is a convincing argument to dismiss the confession. Not only was the officer's conduct a deliberate breach, where no pressing circumstances existed to lift the burden of adhering to procedure, but the gravity of the charges against my client warrant that he is offered the same protection as the legislation provides. The role of having a support person present of the child's choosing during any police interview is to act as a check and protesting against any perceived unfairness or oppressive behaviour, advising the child of his or her rights, which could include a reminder of the right to silence or to admonition against further participation in the interview in the absence of legal advice, and within appropriate limits, assisting a timid or inarticulate child to frame his or her answers to the allegation. None of these were made available to Mr. Ike. Next, I'd like to address the matter regarding Mr. Ike's heritage. Under Section 21 of the Queensland Evidence Act, the court may disallow a question put to a witness in cross-examination, or inform a witness a question need not be answered if the court considers the question is an improper question. In deciding whether a question is improper, the court must take into account the defendant's age, education, level of understanding, cultural background, or relationship to any party to the proceeding. Your Honour, my client is Torres Strait Islander, and this ought to be taken into consideration when reviewing the admissibility of the confession obtained by the arresting officers. You'll notice in the interview transcript that my client had blindly confessed to all 84 complaints of breaking and entering that he was accused of. This repetitive agreement is what is typically known as gratuitous concurrence. Gratuitous concurrence is when a person appears to assent to every proposition put to them, even when they don't agree. For many Indigenous people, like Mr. Ike, using gratuitous concurrence during a conversation is a cultural phenomenon, and is used to build or define the relationship between the people who are speaking. It may indicate respect towards a person, cooperation between people, or acceptance of a particular situation. However, It is widely recognised that people who are in a position of powerlessness, when confronted by alien institutions and authority figures, and who are disadvantaged due to a language barrier, may adopt a strategy of always agreeing or saying what they think the person in authority wants them to say, regardless of the truth of the matter. And this is exactly what has happened here, Your Honour. The repetitive nature of the officer's questions, coupled with Mr. Ike's age and cultural background, is a prime example of improper questioning in practice. I'd ask that the court exercise its discretion and find that the confession obtained by the arresting officers was done so in breach of Section 21 of the Queensland Evidence Act. On these grounds, I ask that the court exclude this improperly obtained confession. Not only had the arresting officers breached the provisions for interviewing a child, the repetitive nature and culturally ignorant questions directed to Mr. Ike has undoubtedly produced misleading evidence that should be excluded from court. With the confession set aside, Your Honour, I appeal to the court to quash the indictment. Without it, the prosecution has no case against my client. I thank you for your time and consideration in this matter.